Right, good morning everyone again. I think we should get started now. So by way of introduction, my name is Sophie Walmsley. I'm one of the barristers within Guildhall Chambers Court of Protection team. You'll also note my co-speaker, Louise Hayes, and you'll also see a couple of other barristers from Guildhall Chambers also in the call today. So Kriti Upadhyay, who is our lead in the Court of Protection team, and our current pupil John Wong, so they may be available at the end for questions as well. But the content of today, as the title alludes to on the screen there, is that myself and Louise are going to talk about mental capacity, and in the particular context of sexual relationships. So that's going to cover relationships and contact. It will cover the act or engaging with sex by itself, and it will also cover contraception and some practical tips for you to take forward in dealing with these sorts of cases. I've already introduced myself very briefly, but I'll just pass over to Louise just so that she can introduce herself to you as well.
Thanks, Sophie. So I joined the personal injury and clinical negligence teams as a tenant in September of last year, and during pupillage I shadowed a number of members of chambers on different court of protection cases. So I drafted orders, position statements and answers to questions from the local authority. My interest in the court of protection stems from my medical law masters, which I studied at Bristol from 2019 to 2020, where I was taught by the brilliant Judy Lang. I'm sure many of you will be familiar with much of her scholarship in this field. I focused particularly during my masters on pregnant women making what are seen to be unwise decisions, given that so much emphasis is placed on women as childbearers and nurturers. What do the Court of Protection make of women who are going against and jarring with that expectation, and how do they marry their best interests with the wishes and feelings of P in the circumstances? I was also very lucky. I had the opportunity to represent an elderly P with dementia making a best interests decision about their residence, whilst I was volunteering pro bono with the University of Bristol Law Clinic. So I'm really excited and look forward to developing my practice in the Court of Protection team.
Thank you, Louise. So getting right into the nitty-gritty, many of you will be more than familiar with the provisions of the Mental Capacity Act and understanding the importance of capacity more generally. But the themes of capacity are going to come up very frequently in these topics, as you would expect for it to do. So it's important to go back to basics. So your first port of call is naturally going to be the Mental Capacity Act, but as well the Mental Capacity Act Code of Practice. Now you'll see from the screen, and it's probably something that you are all very aware of, but there is a presumption in favour of capacity, and that is stated under section 1(2). And then secondly to that a person shouldn't be treated as being unable to make a decision unless all practical steps have been taken to help him or her do so without success. So this is also enshrined under section 1 of the Mental Capacity Act, and this will be relevant to one of the cases which I'll come on to in due course, which is that of LBX. The third is whether a person should be treated as lacking capacity simply because they make an unwise decision. Well, the Mental Capacity Act says no. And again, this is something that is going to feature in one of the cases that Louise is going to talk to you about. Now, it's important to bear in mind that capacity is essentially a two-stage test. So there is the diagnostic and the functional test, and they're enshrined in sections 2 and 3 of the Mental Capacity Act. So looking firstly at the diagnostic test, the question is ultimately, is P unable to make a decision due to an impairment of or a disturbance of the functioning of the mind or brain? And I always draw reference and emphasis to the fact that it says mind or brain, because that will inevitably capture a lot of conditions, not just brain injuries, but also alcohol abuse and disorders of that nature. It's also important to note that it is irrelevant if a disturbance is permanent or temporary. Now, the second element to the test is, as on there on the screen, which is the functional test, which is one that we see courts battling with on a regular basis. And this contains 4 different questions that the court needs to consider, and any capacity assessor. Can P understand information that is relevant to the decision? Can they retain that information? Can they use and weigh that information? And can he or her communicate his decision? Now, capacity is both time and decision specific. And this is relevant when we're talking about the matters that we are today, because whilst a person may have capacity to consent to having contact with, say, person X, they may still lack the capacity to decide whether to have sexual relations with that person, and vice versa. And it's important to be specific in relation to what decision you are asking an assessor or the court to consider. And again, this will be a feature that crops up in some of the cases that Louise and I are going to talk about today. The second bullet point on the slide there is about fluctuating capacity. Now, in cases where somebody has fluctuating capacity, this can make assessing their capacity in relation to a particular decision quite difficult on just a very practical level. Now, depending on the nature of those fluctuations, the courts and indeed any assessors may need to take a more forward-thinking or a more longitudinal approach in assessing their capacity. And then finally, something that's highly relevant in these circumstances, particularly when we're talking about sex, is what the Code of Practice says, which is that if a decision could have serious, grave consequences, then it is even more important that a person understands information relevant to that decision. So what do we mean by information relevant to a decision? Well, section 3(4) says that this includes reasonable foreseeable consequences. And it's important to note that these consequences can extend to others. And again, this is something that will be a repeated theme in some of the cases that Louise will talk about in due course. And one of those consequences might be, for example, the risk of committing a sexual offence or the risk of harm. Now, what is considered to be relevant is naturally going to be highly dependent on the factual circumstances of each case. There is no real one size fits all. And while some guidance can be gleaned from the relevant sources, and that may need to be tailored depending on what circumstances you are presented with. Now, it's also important to note that the court shouldn't be imposing standards that are too high in respect of any decision making. So in another way, the courts shouldn't expect a person who lacks capacity to envisage more consequences than a person who has capacity. There has to be a balance between a paternalistic desire to protect a vulnerable adult, but also ensuring that their autonomy is going to be promoted. This is something that was discussed in Re-M, which is a case that we'll talk about a little bit later. But the judge in that case essentially said that would derogate from personal autonomy in those circumstances. So very briefly, in terms of assessing capacity, well, who can assess capacity? The answer is pretty much anybody, but in practice and in reality, it will usually be conducted by somebody who is familiar with P. So that may be their social worker, maybe a general practitioner, it may be a psychiatrist or a doctor. And it's incredibly important to factor in, again, what decision needs to be assessed, and in the context of whether P has capacity or not. And I'm sure we've often seen cases in the Court of Protection where the questions that are put to the experts in terms of assessment are a little bit more too broad or need more refinement. And then finally, of course, that if you are dealing with a case that's currently proceeding through the Court of Protection, there is the avenue in cases to get a Section 49 report, and they can comment on issues of capacity. I saw recently that the courts are trying to curtail the use of Section 49 reports because they seem to be becoming an almost tick box exercise. But as far as the relevance and the need for it, in particular in circumstances about contact and sex and contraception, these are incredibly big decisions. And so it is even more important that capacity is properly and thoroughly assessed in those circumstances. So if you are going to be considering instructing an expert to comment on capacity, my practical advice would be to ensure that the instructions are as detailed and explicit as possible as to the decision that is being assessed and the information that's going to be relevant to any assessment. So having touched on the basics, I'm now going to talk to you a little bit about relationships and contact, because this is something that will go very hand in hand with sex and sexual relationships. The first thing that's important to discuss in these circumstances is a bit of a background, and I'll come on to that. And I'll also be discussing 3 different cases that have put the context of assessing capacity in relation to contact in due course. So some of the background and some of the important information to consider here is firstly that there is a right under Article 8 for respect to private and family life, and it's also pretty uncontroversial at this point that includes a right to establish relationships with other human beings, and that works both ways. So if you have a case where P wishes to have contact with another, and that other person also wishes to have contact with P, you may find that there has to be a bit of a balancing exercise between both respective parties' Article 8 rights. But it is worth noting that Article 8 is not an absolute right. It is a qualified right, and there can be interference with that. Now, another helpful source is the United Nations Conventions on the Rights of Persons with Disabilities. Now, many of you will be more than familiar with the CRPD. It was essentially ratified in 2009 and is a binding instrument, but it hasn't been incorporated into domestic law, though there are some policies and legislation that seek to give it some effect. But Article 23 is the one that states about respect for the home and family life. And in short, it says that state parties shall take effective and appropriate measures to eliminate discrimination against persons with disabilities in all matters relating to marriage, family, parenthood, and relationships. And in fact, in some of the cases that we'll talk about, the court has gone on to specifically refer to the CRPD. One of the questions that may arise is whether there is a need for a welfare deputy in these sorts of situations, and also more generally. But this was considered in the case of SBC and PB and A and others, and that was quite an interesting decision, because Mr. Justice Wood confirmed that in considering whether a welfare deputy would be required, or the test to be used is that of Section 16, and in his words, the unvarnished words of Section 16. And where the code of practice referring to it being appropriate for the most difficult health and welfare cases, he found that this did not compel courts to find circumstances that are difficult or unusual before appointing a deputy, though this stands in stark contrast with a case that I will come on to shortly, which is that of LBX. But it is something that you may want to consider, as I say, more generally, but can also be a matter of contention in cases involving contact. The second overarching point is the role of the inherent jurisdiction and whether that needs to be invoked. I'm going to come on to this in a little bit more detail because it can have some quite profound effects when we look at some of the case law and whether in fact there is still scope for the inherent jurisdiction to take over, as it were, even if P does actually have capacity in relation to contact. And then finally, again, a bit of an obvious point, but the court needs to avoid taking an overly paternalistic approach when it comes to contact, and assessment of capacity in those circumstances needs to be detached and objective. So the first thing that I'm going to come back onto is this question of the inherent jurisdiction. Now, the courts have clarified that matters that fall outside of the statutory scheme, so that being the Mental Capacity Act, still fall within the inherent jurisdiction. The key case on it is that of Re DL. It was a Court of Appeal decision in 2012. And what the case essentially did was to affirm the earlier decision of Mr. Justice Munby in a case of Re A. And what the court confirmed was that the inherent jurisdiction can be invoked where a vulnerable adult is or is reasonably believed to be, for some reason, deprived of the capacity to make a relevant decision. But went further to say that a vulnerable adult who does not suffer from any kind of mental incapacity may nonetheless be entitled to the protection of the inherent jurisdiction if he is or is reasonably believed to be incapacitated from making the relevant decision by reason of such things such as constraint, coercion, undue influence, or other vitiating factors. So the court went on to consider the role of the inherent jurisdiction in Re DL and confirmed that that was compatible with Article 8 and that any interference by the inherent jurisdiction was to protect P's health or his right to enjoy his Article 8 rights, which were necessary and proportionate. So in short, and this is something to consider in the overall context of contact, is the buck doesn't necessarily stop with the Mental Capacity Act, and there may be some cases where it wouldn't fall within the statutory scheme, but they may still warrant invocation of the inherent jurisdiction. So coming on to the first case that I'm going to talk about today, which is LBX and KL&M. Now, very briefly, this was a very long-standing set of proceedings, and there are various very helpful judgments in this matter. P was a 29-year-old man. He had a diagnosis of mild mental retardation and learning disabilities, and the court had previously not been asked to deal with the issue of capacity because it hadn't been brought in issue. But when it was held that his capacity was borderline. And Mr. Justice Theus ordered a further capacity assessment. Now, I draw this back to one of the earlier points that I made, which is the importance of trying to aid P in his understanding and in assessing capacity. And the judge in this case considered that the assessor at that time hadn't made available tools which would have helped P to understand more, which included things such as drawings and notes and things of that nature. So just a helpful point there. Now, the primary issue in this case when it came back before the court was whether P had capacity to have contact with his father. And ultimately, the family had gotten into a little bit of a conflict with P's placement, and P was sadly caught in the middle of it and at times had wanted to not have contact with some of his family members. Now, when it came back before the court after the further capacity assessment, the judge found that he had the capacity to decide about residence, care and contact, but he said that that capacity was still borderline. And what the conclusion that the judge came to was that he should invoke the inherent jurisdiction to regulate what contact there should be between P and his father to ensure that P could maintain his capacity. And the judge considered that the idea of him maintaining capacity could only be achieved where there was a proportionate structure to keep him safe and free from an emotional maelstrom. Now, Article 8 was engaged for both P and his father, but when the court balanced those, the court considered that it tipped in favour of P because of the risk that his capacity would be compromised in due course. Now, there are some further helpful points from the case of LBX, and that is, what did the court consider to be relevant when assessing capacity to have contact with P's father? And those are, in short, who the person is, and in broad terms, their relationship with P, what sort of contact, so where it is proposed that they will meet, is this going to be in public, is it going to be in private, the duration, is it going to be short visits versus long visits, and any arrangements, so for example, supervised versus unsupervised. He also considered the benefits and risks of any contact. And this was an important consideration because this would factor in what P perceived as any benefit and risk. But the judge did canvass that by saying, unless it was shown that those weren't reasonable or not likely to be true. But what was not relevant? Well, the judge said that the abstract notion of the relationship, such as the importance of family ties, is not a relevant consideration, nor was the possible long-term effects of having or maintaining contact. And finally, it should be obvious, but it goes without saying, risks that aren't an issue. So in this case, that was financial abuse. So the upshot of LBX and KLM and some of the helpful takeaways is that, firstly, we're very much used to dealing with capacity in very binary terms. You have it or you don't. And the characterisation of capacity being borderline, and then the consequence of that then engaging the inherent jurisdiction, is something quite interesting, particularly if you yourself have clients whose capacity may just be there. What is not, what is and what isn't relevant are those also factors that we can consider in looking at cases, but naturally it is going to be determined on a case-by-case basis. Next, looking at a local authority and TZ. So in this case, P was a young man with mild learning disabilities that included autism, and he also had hyperactivity disorder. He did have the capacity to consent to and engage in sexual relationships, but the question was whether he would have capacity to make decisions about his contact with others and his care needs if the opportunity presented itself. Now, the issue when it came before the court and the decision that was being assessed was not very clearly formulated. And again, this goes back to the earlier point of it sometimes pays to be quite specific about what the nature of the decision is. And the judge took a little bit of a Goldilocks approach. He was invited by the official solicitor to consider contact more generally, and he considered that that was too broad. He was then invited to consider if capacity should be considered on a more individual basis. But in the context of this particular case, there were no individuals named. It was more an opportunistic thing that if he did go out and meet somebody, would he have capacity in those circumstances? So the judge considered that that was too narrow. So what the judge ultimately considered the relevant questions to be was whether an individual with whom P wants to have sex with is safe, and whether he then has the capacity to decide upon the support that is required. Ultimately, the judge considered that he lacked capacity for both of those decisions. Although, and again, a helpful point to note, that because P actually had the capacity regarding sex, the state and the local authority had a positive obligation to ensure that he was supported in having a sexual relationship should he wish. And the judge went on to say that that would be consistent with the CRPD. And again, some helpful takeaways from this case is that in cases where you can't necessarily identify a particular individual who you're assessing contact with, you can be a little bit more general, but the way that you need to frame it has to be tailored to the individual circumstances. And secondly, discussing about the nature of the relationships, and even if they don't have capacity to have contact, that doesn't necessarily mean that the local authority or the state can stand back and do nothing. There is still a positive obligation upon them. On a final note, I referred to earlier a decision about the use of a welfare deputy. That was one of the questions that came before the court in this case, and the judge rejected that and said that it would be impractical in this context to refer the decision to anyone else other than those who were on the ground supporting P. And his view on the cases and on the law was that he considered that, yes, you should have reference to section 16, but he didn't dismiss, I suppose, the code of practice guidance about those deputies being required in the most difficult cases. But again, his view is that it wasn't really practical in the circumstances of this particular case. The final case I'm going to discuss is Hill and City Council and KF. Now, this was a fairly tragic case in which P, who had a terminal illness, wished to spend a night unsupervised with her partner, who was due to be sent to prison. And the question that came before the court was whether she had capacity to have contact with her partner, and also in relation to sex. And there's quite an interesting factor here at paragraph 24, which was the judge's observation that it's difficult to see how a person who lacks capacity to decide to have contact with a specific person could have capacity to engage in sexual relations with that person. Sexual intimacy is a form of contact with another. So it goes to show that these questions, whilst they are specific and individual decisions, actually interrelate quite a bit. Now, in this particular case, the judge considered that capacity was person specific, and it was more crucial in the context that P's partner, even though he was waiting to be sent to prison, he'd pled guilty to grievous bodily harm, but in the past had sexually and physically abused P. And this will, I'll come on to this in a little bit more detail. But the judge went on to say that in this context, it was person specific, and it was still entirely logical that P could have capacity to engage in sexual relations on a more general basis, but she may still lack it specifically in relation to her partner. So, as I say, that a lot of information was considered by the judge, and he considered the following to be relevant to the decision. Now, the relationship between P and her partner. And as I said earlier, in these particular circumstances, P's partner had abused her in the past, and the judge considered the violence that had been perpetrated against P. He also considered that one of the foreseeable consequences here was the risk of harm to P. And also, one of the factors that he put great emphasis on was that P could not retain the information about the past assaults that had been committed against her. And in his view, that was highly relevant to her decision-making capacity. Ultimately, the judge said that she lacked capacity to make decisions about contact with her partner, and this included to have sexual relations with him. It was not, therefore, in her best interests, in light of these circumstances, to have unsupervised contact, but the judge essentially said that they could have daily, so in the daytime, contact in public places such as coffee shops, etc. So again, some of the important takeaways is that it is crucial to have regard to the particular circumstances and the nature of the relationship between P and any person that they wish to have contact with. The history between them can be highly relevant, particularly in circumstances such as these, when we're considering the reasonably foreseeable consequences and the risk of any harm coming to P. And finally, that there has to be some sort of practical limit to the foreseeable consequences, but that this case stands as a good all-rounder of the factors that we need to consider when looking at contact in relationships where there may have been issues of violence or domestic abuse. So now I'm going to hand over to Louise.
Brilliant. Thank you, Sophie. So the principles that Sophie has already mentioned in relation to relationships and contact will equally apply to sex cases. For example, capacity can fluctuate. We know that anxiety or medications, for example, might prevent someone from exercising capacity in the heat of the moment. Further, capacity is time and decision specific, and the information relevant to each decision will vary considerably from case to case. But there are a number of unique principles to sex cases which are worth highlighting. And if we just turn over to the next slide, we can see those three are set out there for us. So the first principle is that if P lacks capacity to consent or to engage in sexual relations, then sex is off the cards for a best interest decision. There is not scope for a care worker or for indeed anyone else to make a decision in P's best interests about sex. And that's because it's prohibited under Section 27 of the Mental Capacity Act. Section 27 excludes a number of matters from best interest decisions, including marriage, divorce, sex, and adoption in some circumstances. But the short answer is that sex without consent is rape, and that can never be in the court's best interests. So whilst the court, in many of its decisions, doesn't shy away, and this turns back to Sophie's mention of the Article 8 rights earlier, it doesn't shy away from P's fundamental right to a pleasurable sex life, but that is not to come at the expense of the law. The second point is that the court walks a difficult tightrope here between respecting and promoting P's autonomy and independence versus serving its protective function. The spirit and ethos of the MCA is to put respect for P front and centre. The presumption of capacity needs to be displaced, and you need to take all reasonable steps, or practicable steps indeed, before finding that P lacks capacity to make a decision. But the court is also a protective body. It's aware that P's under the jurisdiction of the court are likely vulnerable, and the court's there to safeguard and prevent harm from occurring. So inevitably it does have to make decisions which will limit P's freedom on occasion. In many cases, we can see a tussle between these two competing principles, and that was a key consideration of the Supreme Court and Court of Appeal in the key case of JB that we'll talk about in a moment. But ultimately, a balance needs to be struck between the two factors there. The final point: is sex person-specific or issue-specific when it comes to capacity? So many courts have considered this question since the case of Re-M, decided in 2014. For the moment, generally, bearing in mind, of course, Sophie's comments earlier, sex capacity is issue-specific rather than person-specific, and this seems to be grounded in logistics more than anything, because it would pose a difficulty for local authorities to decide capacity in respect of each and every sexual partner that P might conceivably have. My own reading on the cases here is that the waters are rather unclear, and arguably the question is somewhat superfluous. We can see judicial creep, as Sophie mentioned earlier, in the case of KF, where P's partner was abusive, and therefore, given that P couldn't retain the information about the sexual assaults, she didn't have capacity to engage in sex with her partner. The Supreme Court in JB agreed with Lady Hale, as she then was, that it's difficult to think of an activity which is more person-specific than sexual relations. And for what it's worth, I agree with that sentiment. I think it takes two to tango, and it's difficult to see how the identity and characteristics of who P is engaging in sex with can be overlooked. I also don't think that the tests here in terms of issue specific and person specific are mutually exclusive. I think that they can work in harmony together. So personally, I'd say this area is ripe for judicial comment in the future. So keep an eye out as to future cases. Looking now at the test for capacity, it's critical to remember this test is not simply does P have capacity to consent, but does P have capacity to engage in sexual relations? Consent is misleading in some circumstances that we'll come on to later because it implies agreement from a proposing party. It overlooks the fact that in many cases, P will be the person initiating that sexual contact and relationship. Relevant considerations may include, and there's an emphasis on the may there because the court in JB made really clear information relevant to the decision will vary in every case. As Sophie said, there's no one size fits all model here. It's not a prescriptive checklist. But in terms of points common to many cases, the first point, does P understand the mechanics and nature of the sexual act? Do they understand the physical and practical aspects of what they're engaging in? The second is, do they understand that their partner, in addition to themselves, needs to consent and indeed consent throughout? Sex is a shared activity. It takes two to tango, and both P and their partner need to have capacity to consent before and throughout. It's critical that P understands that consent ultimately trumps all, and a reason doesn't need to be provided for that withdrawal of consent. It's sometimes a nuanced point because in several cases that I've read, P has struggled with this concept, given their impairment or disturbance might produce a binary, a black and white view. But ultimately, it's critical that P understands that. And finally, just briefly as to STDs and pregnancy, in some cases these fall away. For example, where P is in a monogamous relationship with a long-term partner, STDs aren't a relevant factor. And further, in pregnancy, this isn't at play when P is not heterosexual, if they're infertile or post-menopausal, for example. But where they do come into play, the understanding required generally is not particularly complex. As to STDs, one needs to understand that they can lead to ill health, and as to pregnancy, one needs to understand the general concept of carrying a baby and giving birth or a caesarean section or other alternative at around 9 months or so. If we turn then to the next slide, we can consider what then is not generally relevant. So we've already touched upon the identity and characteristics of the partner. And as I've said, I suspect we will see judicial development in this field, but for the time being, it's generally an issue-specific matter. And then as to pregnancy, P is not required to understand how to care for a child, nor the risks caused through pregnancy. These are quite advanced concepts, so P is not required to understand them. Let us now consider the case law when we look at the next slide and what practical guidance we can lift from these cases. So the first case to consider is a local authority and JB. This is the leading case on the test for capacity and sex, and it deals with the question posed earlier. Is it capacity to consent or to sexual relations or to engage in them? What is the test here? And further, does P need to understand the consent of the participating party? So just briefly on the facts, P was 38, he lived with Asperger's and brain damage, and he displayed inappropriate sexual behaviour. This involved fixating on women, sending inappropriate messages, inappropriate touching, and targeting vulnerable women. He would lead them into places, for example, public bathrooms, where he thought his activity could go undetected. His number one priority, in his own words, was to get a woman as his sexual partner. He told experts he would have anyone. And indeed, he made a beeline at many women at dancing clubs where he was later banned from. He had no interest in relationship or companionship. He was solely motivated by the physical pleasure of sex. He had capacity in several areas, but his understanding of consent was extremely limited in terms of his prospective partners. He defined consent as one party allowing the other to have sex without the other party complaining. As to withdrawing consent, he stated she, being the partner, can't change her mind if you're already doing it. But he had no issue in terms of his own consent and that he could withhold it. In the first instance court, Mrs. Justice Roberts held that the question is one of consent. So there's no need here to consider the consent of his partner. But this, of course, doesn't gel with P being the instigator in the circumstances, and nor does it resonate with her comment that sex is essentially consensual. It necessarily has to be consensual in order to be legal. So why that information would be relevant is perverse. She also places huge emphasis on P's right to sex in quite a visceral way that, in my reading, is different to the cases, for example, of H and TB, where, interestingly, those involve female Ps and are decisions from male judges. So I wonder if there's a gender balance here, and if that speaks to our assumptions about what men and women, what we think men and women value from sex respectively. It may, of course, be a coincidence, but that's my personal reading of those cases. So the first instance court held that understanding the consent of the participant was too high a test. Of course, it's unclear why that conclusion is reached when it's obviously essential to provide one's own consent, and the natural corollary of understanding your own consent is that you'd be able to understand another person's. So the Court of Appeal and Supreme Court unanimously reframed that question. They said it's not consent, this is a matter of engaging, and when framed in this way, the consent of the participating party is obviously essential. They also dismissed the suggestion that that's too difficult of a test. And they also held that it was reasonably foreseeable here that he might commit sexual offences. And that's information that he needs to understand about their decision in order to give their in order to have capacity in the circumstances. And I bear in mind, of course, the paragraph 4.19 of the MCA Code of Practice that Sophie mentioned earlier, the fact that where decisions could have really serious or grave consequences, such as going to prison or being hospitalised or psychological and physical harm from others, it's important that he understands that information that's in play here. Given the reframing of the question, it was appropriate to remit the case back to Mrs. Justice Roberts in the circumstances. So we don't know whether the court considered that JB had capacity or not. So if we look at the next slide, then this is the application of JB in the recent case of PN. And here Mr. Justice Poole had three things to consider. One, did P have capacity? Did he need to disclose the fact he posed a risk of sexual harm to others? And what is the local authority to do about disclosing the risk? So here, if we look at the facts, PN had a lifelong history of sexual touching, assaults and comments. All of his assaults were opportunistic, but he acted in a predatory manner and posed a significant risk of harm. The experts here considered that whilst P offends, it's not due to his lack of capacity. His impulses were rooted in character. And the court agreed with that assessment and found that he chooses to surrender to the impulse, but that does not mean that his ability to use the information is lost. Thus, the court had no jurisdiction given that P had capacity. So whilst it might disapprove of P's actions, it's not the place of the court to interfere there. Disclosure, just briefly, is a tricky one because logistically the court questioned, well, how is this going to work? Will P wander around with a sign on his back to the effect of, I have committed sexual offences? The judge acknowledged, indeed, that people with capacity may well struggle with decisions about how and when to share that information, and therefore essentially dismissed it from being relevant to the capacity decision there. The judge also considered, is there a tension here between findings of capacity in relation to sex, but incapacity re-contact, as Sophie touched on earlier? And the short answer is no. The sexual boundaries are more clear-cut here for PN, who can understand firm no's, whereas the social boundaries are rather more nebulous and vague. The final case on sex is the case of Secretary of State for Justice, which is on the next slide, and that's a 2021 decision. And in this case, P had capacity to consent to sexual relations and have contact with a sex worker, but they lacked capacity to make those arrangements for themselves. So the court was asked here, can care staff legally make the practical arrangements, such as booking, paying, and sorting the transport out for P who wants to go and visit a sex worker? Now, Section 39 of the Sexual Offences Act 2003 states that a person, aka a care worker here, commits an offence if he intentionally causes or incites another person to engage in an activity. that is sexual. So the short answer is no, it's not legal to facilitate the practical arrangements for sex. It puts P in peril of committing an offence. Just rounding off the focus on sex before we turn over to contraception. Firstly, as we explored earlier, the relevant information will vary significantly from case to case. Consent is for P and their partner, not just for P on their own. That's a short-sighted approach. And the tests for capacity are different. That doesn't mean that, although on the face of it, a sex and contact, for example, go together, it doesn't mean that the court can't make seemingly inconsistent findings there and for those to be acceptable. As Sophie was mentioning earlier, the fourth point, questions throughout whether P can gain capacity. Experts will usually offer a view on this, but it's important to ensure that P is supported wherever possible in order to gain capacity. And finally, a higher standard isn't to be imposed on P as to capacity. It needs to be identical, in short, for someone with capacity. Turning now to contraception. So unlike sex, if P lacks capacity, a best interest decision can be made. So section 27 doesn't prohibit a best interest decision on that front. And we can see the test set out by Mr. Justice Bodley. He raises 6 points that P should understand: the reason for contraception, what it does, the types available and how they're used, advantages and disadvantages of each type, the side effects of each, and how easily they can be changed and their general effectiveness. So when we look at the application of this, a recent case, the case of Z in 2020, here P was a 22-year-old woman. She was heavily pregnant with her 5th child and she lacked capacity as to contraception. So the trust said we should be inserting rather an IUD, also known as the copper coil, to prevent the risk of future unplanned pregnancy at the same time that P has her cesarean. So P was willing to have long-lasting contraceptive injection, but she didn't want the coil to be fitted, and she stated, "It's my body, I don't want it." But she couldn't provide further elaboration beyond that. So it was held that she did not have capacity in the circumstances, and the court decided that it was in her best interests to have the coil fitted, which on the face of it is surprising given how invasive the experience of having a device fitted into your body is in principle. But the court bore in mind her previous pregnancies. So here P had a lot of medical conditions which posed her pregnancies as a serious medical risk for her and her babies. So while she was very frightened of medical intervention here, the court no doubt balanced the fact that the coil being inserted and fitted and removed and replaced where necessary is something that takes between 5 and 10 years, whereas if P were to get pregnant through less effective contraception, and particularly contraception that relies on one's own compliance with that, then it would involve a lot more medical intervention than having the coil here. So that is an overview in a nutshell of their decision making. And then the final case that we will consider this morning is the case of Miss V, which is a 2017 decision. And here P had a severe learning disability due to brain damage, cerebral palsy and epilepsy, and she presented to her GP pregnant. It was quite a curiosity as to how this had happened in the first place, given she lacked capacity to consent to sex. And the local authority initially, given this, sought a sterilisation, but later changed to an order for the contraceptive patch, the purpose being it's a just-in-case measure in case the safeguarding plan for P fails, as it has done in the circumstances. And the court found that P lacked capacity here, but it bore her interests and her best wishes in mind when deciding that a trial period for 6 months of the contraceptive patch was in P's best interests. And it acknowledged that the drawbacks of contraception were relatively modest compared to the obvious disadvantage to P if she became pregnant again. The court acknowledged, however, that the patch may well have some side effects, so it's good to give this a trial period for no more than 6 months to see in short how P gets on with it and whether it is an effective solution. I, in my personal view, would not be surprised if we see more cases in the future where trial periods, particularly for things like contraception, where individuals with capacity may well trial a contraception for a period of a few months to see how it works out, become more common in the cases that we see. So again, that's something to keep an eye out for future cases. I think that brings us to a close on all of the cases and practical guidance that we wanted to give this morning in our webinar. I think now we have an opportunity for a few minutes for anyone to ask questions. Please feel free to use the chat function. Again, I don't know if Critty and John are still here, but they too, I'm sure, if they haven't dashed to their hearing yet, will be more than happy to assist in answering questions if there are any. And further, I know that our email addresses are listed on the last slide, if any spring to mind after this webinar that you'd like to ask us that arise from anything that we've discussed this morning.
I can see that Critty is here very briefly, but has to dash off. But thank you all for coming today. We hope that you found the talk useful. In particular, issues in terms of capacity to consent to sex and to have sexual relationships is quite a complex consideration, and there's a lot that goes into it in terms of the nature and the evidence, and also how the courts are prepared to approach these sorts of cases. And you'll note that we've said throughout, well, it's going to depend entirely on the circumstances of your individual cases, but we hope that you have found it useful. I've seen from Charlene whether the slides can be made available. Absolutely, they will be circulated, and this webinar hopefully will also be uploaded to YouTube. I'm not sure if it will, but usually that's what we try to do, but you should have them in due course. And you'll also receive a handout as well with some bullet points of the matters that we have discussed today. But if there are no questions, again, thank you all for coming this morning, and we hope that you have a lovely day. And as Louise has indicated, if any of you have any questions that come to mind, feel free to email us.
Thanks so much, everybody.
Thank you.